Well, once again, good morning. We appreciate everyone's patience this morning. Obviously, this would be a whole lot easier in person, but we are still, figuring out Zoom a year and a half later. But my name's Andre Del Valle. I'm the Senior Director of Government Affairs for the Pennsylvania Apartment Association. And we're joined today by Sue Wasserkrug, who's the Director of Mediation for Cora Services and Good Shepherd Mediation. And then we have Vikram Patel, who's the Supervising Attorney in the Housing Unit for Community Legal Services, who will be our presenters today. As I mentioned, we do have a Q&A feature. We're going to try and get to questions towards the end, but I definitely wanted to allow Sue and Vic to talk about some of the changes to the eviction diversion program and really provide some updates that I know are going to be very informative to all the attendees this morning. So without any further hesitation, Sue, floor is yours.
Vic, do you want to share the PowerPoint? We're going to get the PowerPoint up and then I'll get started. Oops. Great. Well, good morning, everybody, and thanks for joining us today. We just had introductions, so thanks for introducing us, Andre. As Andre said, my name is Sue Wasserkrug, and I'm at Cora Services, I'm the Director of the Mediation Department there. Just so you know, we're going to be these are the topics we're going to be going through with you today. We'll talk a little bit about how you apply for the eviction diversion program. Well, actually, even before we do that, we'll give you sort of the updated version of the eviction diversion program applying, and then we'll discuss a little bit about this new alternate pathways of diversion. Then we'll show you a sample of the outcome document that you'll receive once you've completed the program. And then we'll also share with you the status page, what that looks like and what you need to do with that. You want to take over, Vic?
Sure. Okay. So quick rundown, and also a little bit of stuff that's goes before this. Right. Eviction Diversion Program first created in 2020 as part of the Emergency Housing Protections Act. First version went into place September of 2020. The requirement to go through diversion, that version of diversion expired in at the end of March 2021, but then was sort of extended through a court order through the municipal court through the end of last year, which then gets us to the most recent version of the program, which was put into place by City Council at the end of last year, starting at the beginning of this year. And it requires, all landlords to apply for diversion before being able to, file an eviction case in court. There's one exception, which is imminent harm. If you're in a situation where the tenant is putting you in imminent harm, you can go straight to court. You don't have to go through the diversion program. And then after applying, and Sue will get into this a little bit later, the application will be put on currently one of two pathways. And then the legislation also requires good faith participation. So to engage in the program in a good faith manner, to try and work something out before going to court, to try to I guess avoid the parties needing to go to court. Okay, so first thing, there's a new, I guess as of a few months ago, notice of diversion rights. I'm going to go and pull that up and show you where you can get it also, because one of the requirements is to serve this notice of diversion rights, send it to the tenant. So I'll show you where you can get it. So if you go to this is blocking my eviction-diversion.phila.gov. And then I think it's in the About section. And then in the about section, right, there's a ton of information. A lot of the information we're going to be talking about today is also available online in the about section. But if you scroll down toward the bottom, it's got a handful of links, but one of them is the notice of diversion rights. So it's 2 pages. First page is in English, second page is in Spanish. But it's something that when you send it to the tenant, it informs them about diversion, that you're going to be participating in the diversion program, and what the diversion program is, and what their next steps are to participate in the program. So, right, it talks about what diversion is. Their next step is to call the hotline, and also to contact you, try to work something out. Right here, I'll go back to slides. So I think that covers the notice and where you're going to apply. So I'm going to switch it back over to Sue, who's going to talk about applying.
Great, thanks. So, and on the page that Vikram just pulled up, you'll see a little button that says apply now or apply here, something like apply now, that blue button down there. So, that's where you'll go when you're ready to apply. And what you'll need before you even sit down to apply, you'll want to make sure you have all of this ready to go, so that some of the information is required. You won't be able to proceed with the application without the information, and some of it you may be able to proceed, but when the application is reviewed, it will be rejected. So let me just go through this really quickly. We need to have your rental license number. There are, which, as you know, you need to have a rental license in order to rent a unit. And of course, you also need that rental license number in order to evict a tenant. So since this is a pre-eviction filing program, you'll also need that for the eviction diversion program. Now, I know there are a couple of exceptions to who needs a rental license, and this isn't exactly my area, so feel free to jump in, Vic, but I think it's if you're renting to an immediate family member, and if you're renting a room within your house, those are the exceptions. So if that describes your situation and you need to let us know that you don't have a rental license, then just upload a document with the rest of your uploads, which I'll explain in just a minute. Some sort of an affidavit saying I don't have a rental license because my tenant is an immediate family member, or whatever the case may be, that allows you to rent without having a rental license. So you'll want to have that number handy. You'll want to have contact information. And when we say contact information, we're looking for, this is both for yourself and specifically for the person who will be engaging with the tenant, whether that's through mediation or through an alternate pathway. And the contact information should be ideally a cell phone number, because you will be receiving automated messages, text messages. So it's best if you can put in a cell phone for both yourself and your tenant. In the absence of a cell phone number, if you don't have that number for your tenant, or if you happen to not have a cell phone, then you have to put in an email address. And because if you've done this before, you may know that you'll be getting those automated notices by both text and email if you have both of those pieces of information. If you don't, at least you and your tenant will be able to get the information by text or email. So we really need one or the other. If you can't provide that information, there's no way that you will know how to proceed through the program. That is how the city has designed the program to communicate with participants, is through text or email and through these automated messages. And then, you want to be ready to to tell us at the appropriate point in the application what the issues might be that are causing conflict between you and your tenant. You know, we realize that in most of these cases, the primary issue is going to be rent, back rent that hasn't been paid. But sometimes there may be other issues. Sometimes rent is not an issue at all. Sometimes it's some other kind of a breach of the lease that is causing a problem. So, just be ready to tell us about those other issues. If it is a question of back rent that is owed, then we'll need some kind of a ledger. And this doesn't have to be, you don't need to have some kind of fancy program that creates a ledger. It can even be a handwritten document, but it needs to spell out what is owed and why. So you can't just upload a document that says tenant owes $3,000. It needs to say, just for example, and the ledger needs to have the tenant's name and the address of the unit on it. So, at the top, you'll have the tenant name and address, and then you'll want sort of a list. If you're doing this by hand, you may have a spreadsheet or something, but you'll want to have a list saying, for example, January 2022, $1,000 rent. January 15th, 2022, $50 utilities, something like that, that really clearly documents how you got to $3,000 or whatever it is that you're saying that the tenant owes. So just a very detailed list breaking down what the tenant owes. That's what we need in the ledger. And then it's great if you can tell us, what kind of an agreement would work for you. You can handwrite that. You can find a sample, sort of a template on the website, that list where Vic just showed you the list of all the information on the about page. There's a sample of a proposed agreement. You can use that. You don't have to use that. But that's there for your convenience. And there's a sample rent ledger, there's a sample agreement form, just something letting us know, what would work for you that, might be realistic for the tenant. So again, if the tenant, just using an example, if the tenant owes $3,000, a proposed agreement saying the tenant should pay the $3,000 tomorrow. We understand that it's been a while since, you may be having a problem with your money, but chances are that's not going to be something that the tenant is going to be able to handle. So, some kind of a proposed agreement that, based on your relationship with your tenant, that you think the tenant might be able to follow through with. So that's the point of the proposed agreement. The proposed agreement is not, and you can upload a proposed agreement whether there's rent owed or whether there's some other issue happening. Either one of those is fine. And then we'll need some sort of proof that you actually did provide that notice of rights that Vic showed you earlier, some kind of proof that that was delivered to the tenant. We realize people deliver these notices in a lot of different ways. It can be, we like to see, and actually now, as of a couple of weeks ago, I think it was, we need to see a copy of the notice that you delivered, because it's a new notice. There have been several variations of this notice over the last year and a half. And the one from a year and a half ago is completely out of date and will provide incorrect information, or outdated, I should say, information to the tenant. So we need to make sure that you've provided the current notice of diversion rights. And so you'll want to upload a copy of that and some kind of proof that you actually provided that to the tenant. What many people will do is provide you know, send it certified mail and show us a copy of the certified receipt, you know, the receipt that you get from the post office with the tenant's name and address on it, that's fine. It can be in, it can be on, you know, you can upload that separately. You can sort of tape that to the top of the notice if you want and upload it all as one document. You can upload, sometimes people will send it in an email. You can and ask the tenant, please confirm that you received this email. And once you get that confirmation from the tenant, you can upload that. Some people will post it on the door. That's a little more difficult because it's hard for us to know, you know, whose door is this you're posting it to. You know, in a last case scenario, you can always, again, write an affidavit and sign it and date it saying that I provided this document to tenant so-and-so on such and such a date, by handing it to them, you know, or by, if you mail it, then you can send us a photo of the front of the envelope that you're mailing it to. But if you're hand delivering it, you know, some kind of affidavit that you actually hand delivered it to the tenant, that would work as well. Also, I just wanted to mention before we move on, we've created, well, I shouldn't say we, one of our partners, because I am not the star of the video, but one of our partners has created a video where they're actually going through the application process. So we're not going to do that for you today. We're just, you know, we're going to explain some things today. But you can view this video. Hopefully it'll be uploaded to the website very soon. I don't believe it's up there yet, but it will be soon. So you might want to actually watch that video. I think it's maybe 5 or 10 minutes, and it will actually walk you through the process. Let me just mention one thing in terms of uploading documents. So mostly you'll be answering questions, filling in information, but at a certain point you'll need to upload the ledger if you're requesting rent. You'll need to upload some sort of proof of delivery, and you'll need to upload a proposed agreement if you choose to do that. That proposed agreement is not mandatory, but it is really helpful to the tenants. And just sort of a tip that will make it easier for the reviewers. If you can gather all of those documents and create one PDF to upload just all as one PDF, then the reviewers, it'll speed up the review process, because then the reviewers only need to open one document. And it would also be really helpful if you would name that PDF the name of the tenant, for example, or the address. The name of the tenant would be great, but the address, you know, as opposed to some random name that the computer gives you when you create a PDF. That's, you know, that's not required. It will just speed up the reviewing process for you and for the reviewers. Okay, so you've applied. What happens next? Your application will be reviewed. There we have a team of reviewers who go in and look at every single application. Actually, I think before your application is even reviewed, once you hit that submit button, you'll receive a notice saying your application has been submitted and here's your EVP number. So you'll want to keep track of that EVP number for future reference. And then within a day or two, the application is reviewed. I say within a day or two. However, if you apply after 5, anytime after 5 on Friday up until 9 on Monday, you know, it's a day or 2 business days. So you'll have to wait a few extra days. If you apply on the weekend, same thing if you apply on a holiday when the offices are closed. The reviewers are doing their, you know, their 9 to 5 staff. So they won't, if you submit at 6 o'clock on Friday, chances are your application won't be reviewed until sometime on Monday. or possibly even Tuesday, because, we usually do them within about 24 to 48 hours. So the application will be reviewed and you'll receive notice saying, it'll either say your application's been approved. And at that time, the tenant will also receive a notice saying your landlord has applied, here's your next steps. Or it'll say, your application was rejected for this reason. You didn't provide a ledger. You're requesting rent, but you didn't provide a ledger. For example, I'm giving you an example. If the reason that your notice, I'm sorry, that your application is rejected is because you've failed to provide a required document, you can go back into your document or your application and just upload that document. And the notification that you get will also include a link to additional information on what to do now that my application has been rejected. If it's something like a lack of contact information, or lack of a rental license number, then you actually have to go back in and reapply. If you didn't put in any contact information for yourself, you'll never know that your application has been rejected. You might, I'm actually, at that point, you probably should have gotten an EVP number. So you can probably check that on the status page. But that's why it's really important to put in contact information for yourself as well as for your tenant. Every once in a while, there's some sort of unusual situation where we might just tell you, one of the reviewers who's reviewing your application might include an email address and say, if you have any questions, reach out to this particular email address, because there's something unusual about your particular application. I mean, we realize that may happen from time to time, but for the most part, you'll be directed to the website with all of the information, and you'll just need to double check your application. Okay. And then what happens if your application is approved? As I said, you and your tenant will receive notices. These automated notices will be coming from the city of Philadelphia. They don't come from, we are an independent nonprofit organization. So those automated notices are not coming from our office. If you're assigned to mediation, as Vic mentioned, there's different pathways right now. So if you're assigned to mediation, which, because all diversion for the most part included mediation back when the program started during COVID in September of 2020, people sort of associate mediation with diversion. But as Vic said, now we have different pathways. But if you're assigned to the mediation pathway, then your tenant will be assigned to a housing counselor. Actually, then your tenant will be assigned to a housing counselor. And once the tenant and the housing counselor are have a time to talk before the mediation, and that's again why that ledger can be, or not the ledger, well, the ledger and the proposed agreement can be really crucial here, because the housing counselor can go over that information that you've provided with the tenant and try to figure out, is this something that the tenant can agree to? Would it be useful to sort of tweak the agreement a little bit? Does the tenant have any concerns about the ledger, about the other issues that you may have mentioned? So they'll have a chance to meet, and then both of you will receive a date and time for a mediation session. Again, this is only if you're assigned to the mediation pathway. And then, and along with that information, with the date and time for mediation, you will receive contact information for the housing counselor. It's not always the email of the exact person who will be the housing counselor for your tenant. It might be contact information for the housing counseling agency where that housing counselor works. That's, that's the information that's being provided, but you can reach out to that person if you choose to do so. And then a day, about 24 hours or so before the actual mediation is scheduled, you'll receive another one of these automated messages, which will give you as call-in information, because all of these mediations, for those of you who may be new to this, all of these mediations are done by telephone. So, and it's sort of a typical conference call situation where you call a number and then it tells you to enter your 5-digit code. So you'll get that 5-digit code a couple of days or a day or two before the mediation. Just a little pro tip here, that call-in information, it's always the same. So if you have a lot of tenants and you're doing this a lot, that phone number at 215-701-2767, I think, don't write that down, but that number is always the same. It's the 5-digit number that will change for every mediation that you participate in. So you'll want to look out for that a couple days before the mediation. The mediation, if you're assigned to a mediation, it will occur before 30 days have passed since your application was approved. So, and usually it'll be more like, within 25 days, because then we need to process the outcome of the mediation, and that may take a day or two. So your mediation should take place within 30 days of the date that your application was approved. Again, your application will be approved within a day or two of your submitting the application, assuming that it's complete. Of course, if it's not complete and you need to resubmit it, that just, whatever date it's then approved on, within 30 days of that date, you'll receive some sort of notification that some sort of outcome document, which in fact is what Vic will talk about next. Let me just really quickly tell you about the different pathway. If you're assigned to a pathway that does not include mediation, then again, you'll just want to reach out to your tenant. That's again where this proposed agreement can be a good starting point for that with the ledger. You'll also get some information, you and your tenant both will get some information on where to find some resources to negotiate an agreement on, and I believe all of those resources right now are on that same about page. So there's some resources there. If you you can just go ahead and reach out to them. If they reach out to you, be sure to respond to them, because otherwise they may notify us that you're not responding. And responding is part of the good faith, which we'll talk about in a minute. So, okay, let me turn it back over to you to talk about the outcome document.
Okay, so this is one of the newer items is this particular outcome document. So this is an example of if you get to the end of right when you get to the end of the pathway, you receive this, which is a document that outlines essentially what happened in mediation. Now, not the actual mediated agreement, but whether or not an agreement was reached, whether or not also whether or not the parties participate in good faith. So we see here three different outcomes, right? Agreement reached by the parties. So participation is complete in the program. Participation is complete in the program. and more than 30 days has passed. So essentially, enrollment in the program is complete, or participation is not complete because of either some issue with the application, or there wasn't good faith participation. I think the most common example that I've heard, right, that comes up for lack of good faith is just not showing up, not showing up to mediation. In which case, if you miss the mediation, contact Court of Good Shepherd, and they'll be able to schedule another, reschedule another mediation. Now, this particular document, right, because participating in the program is a requirement before being able to file in court, or before being able to evict someone in court. This is something that you would be able to take to court if things don't work out in the program, and show to the court in order to show them that we've participated in the program and the program is finished. So this is the version that's an email. There's also a text message version. But let's say you don't have, let's say you misplace all of those. There's now also a status page, and I'll show you. So this is a screenshot of it, but I'll just go to the status page itself. So the status page, just go to EvictionDiversion.phila.gov, and then click on status. You can put the EVP number in here, and that'll bring up the information about what's going on in the program. You can enter this at any point during the program, and it'll tell you what stage you're at in the program, like whether you're finished, like what the outcome was, whether there's a mediation scheduled. So some of the things that are really key here is right here is where we have the outcome. So in this particular case, there was an agreement that was reached. Down here, if you're still in the program and there's a mediation scheduled, down here at the bottom is actually where you can find the that phone number that Sue was talking about earlier, that phone number and your call-in code. So if you somehow misplace the call-in code, you can go here to the status page in order to find it. So it's always available if you go to the status page. Finally, right, if you misplace your outcome document, this is the other place where you can get it and then print it out and then take it to court if you need to go to court. All right, so last, good faith participation. So good faith participation is required by the legislation in the program. So some of the things that are required under that are requirement to provide the tenant with the notice of diversion, provide contact information, at least to the best of your ability, for the tenant, to respond to the program, attend the mediation. Once again, attending the mediation is or lack of attendance at the mediation is the most common reason for something being marked lack of good faith. And then also, engaging with the mediation itself during the mediation. And if the program sees that there wasn't good faith participation, that's going to show up in that outcome document down here at the bottom. So I think that covers everything that we had.
Great, and thank you so much, Vikram and Sue. I've had the pleasure of working with both of you and Rachel over at CLS, and I know we have a lot of questions in the Q&A and in the chat, but they have been willing to listen and really hear the concerns and some of the procedural issues and challenges that landlords have been facing. So I really appreciate you guys, all the hard work you're doing, and obviously for putting this presentation today. I did want to kind of go through some of the questions in the chat since we have a few minutes here. But Priya asked earlier if you could explain what the acceptable imminent harm reasons which can be included in the diversion exceptions, like some of those situations, if you wouldn't mind.
Yeah, so imminent harm actually, well, it's not outlined exactly in the in the legislation, right? Because there's so many things that could constitute imminent harm, and it's something that the program actually doesn't make a determination on. If you think you're in a situation where there's imminent harm, the next step would be to go to court, and then it'd ultimately be a judge that would decide whether or not the situation you're describing would fall under imminent harm. But I mean, some examples would be, the tenants threatening you, or the tenant has is doing something that is actively, because I think imminent harm also can fall under imminent harm to the property itself. So something that's happening on the property that is actively destroying the property might fall under imminent harm also. But once again, it's up to a judge in municipal court to determine whether or not something falls under imminent harm. Yeah, so if you're looking for an imminent harm exception, that wouldn't be something that the program would be determining. It would be the court, after you filed, that would be determining whether or not the situation warrants the exception.
Gotcha. Thank you, Vikram. So we had another question. Can you please discuss the timeline from the time when the housing counselor is assigned to mediation? So I guess it would be, what does this process look like from the moment someone applies for the program, and then when the housing counselor gets assigned? What is those timeframes that we're looking at there?
The housing counselors, I believe, are usually assigned within about, give or take a week. Because remember, this whole thing is happening in 30 days. So once you're approved, then within a couple of days, once you're approved, then shortly thereafter, the housing counselor might be assigned. And the housing counselor might be assigned, again, just for example, on a Monday, and the appointment with the housing counselor might be for that Friday, and then the mediation might be the following week, or it might be the week after that if that's still within the 30 days. The housing, as you may know, if you've been working on this, there are lots of housing counseling agencies, and they all have different schedules when they're available for meeting with tenants, and also when they're available for mediation. So that's what's driving all of that scheduling, is the specific availability of the different housing counselors. And that's why you'll be assigned a mediation date and time. Of course, if there's a valid reason why you can't appear at that date and time, you can reach out, and we do try our best to reschedule. If you're going, another pro tip, if you're going to request the mediation to be rescheduled, as I mentioned in the notification you'll receive, there'll be an email address for the housing counseling agency. So copy that person when you reach out to us, include that email when you reach out to us asking to be rescheduled, so that that person can weigh in. If you're assigned a mediation date and time of, Tuesday at 2 o'clock, and you would prefer Thursday at 9 o'clock, include that person so they can respond and say, hey, I have a doctor's appointment Thursday at 9, I can't make it. How about such and such? Because that'll just speed up the rescheduling process.
Gotcha. And if the mediation date's more than 30 days after like the application gets approved, is there anything that prevents a landlord from proceeding to court on the 31st day, or how's that date? How's it go from the date of approval?
So after, do you want to take this, Vic, or you want me to handle it?
Sure. Like, if it's past that 30 days and, the landlord has participated in good faith up to that point, then they can go to court. Right. The requirement is only within those 30 days. And so on that, after those 30 days have elapsed, if a mediation has not been scheduled, the landlord can file in court.
And I believe what's happening is, let's say you file in court on day 31, and let's say your court hearing, is out on day 45, but your mediation was scheduled for day 35. You still have to come to the mediations, because otherwise, I think if you go, and I'm, I don't practice in municipal court, so correct me if I'm wrong, but I think if you go to court and you hadn't been, there's still the requirement in the ordinance to participate in mediation if you're assigned to a mediation and that date occurs before your hearing. Is that right, Vic?
Yeah.
Okay.
Yeah.
So I'm going to read just a few comments here. The first one is agreements made in diversion were thrown out when we went to court and had to come into a new agreement. What then is the point of diversion if it's not just to delay the process? Not sure if anyone wanted to grab that one.
Well, yeah, I guess there isn't a requirement. There is not a requirement to, once you get to court, to come to a new agreement. But I would say that, right, the point of the program is in order to avoid court, if at all possible. And right, sometimes you can't avoid court, but the intention of the program is to work things out without having to go to court. Once again, right, that doesn't always work. And so I do appreciate that position. But the intention of the program is to avoid going to court if at all possible.
Gotcha. We had another comment that was, we delivered a notice via mail and it said the property was vacated. They went to the property. It was clearly visible that they were still living there. And they resent it, but is there any way to avoid this from happening again in the future, where a notice gets denied because it may look vacated?
Sue, you were talking about filling out an affidavit or something like that, describing, I guess, the steps that were taken.
Exactly.
And so just describing the steps that were taken in order to provide notice, I think sounds like that would be sufficient.
Mm-hmm. Exactly.
We had, and do we know what percentage of the cases are going through mediation right now?
I don't think I have that.
Yeah, I don't have, it's, that information must be available, but I don't have it at my fingertips.
Gotcha. Yeah,
I know that's not something that our agency handles. So
yeah, we can circle back. I think that was Paul who asked that. Why do we need to apply through the diversion program if no rent is requested and the property is being placed up for sale?
Yeah, so this is one of the changes in the legislation. The legislation that was passed in 2020 was only for non-payment of rent, but City Council changed it. City Council changed it so that way it's all landlord tenant cases, with the exception of imminent harm, have to go through the program. So the answer essentially is that City Council changed the law. And so that's why there's the requirement to go through it.
There are other questions that are very kind of specific to certain cases. So what I'm going to recommend is for those folks who have specific questions about like a specific case to reach out, and we can drop that email in the chat later, because I just want to kind of cover the macro questions. We had another one that said, what if the tenant doesn't have a cell phone? And I know this is something that we've discussed.
Well, if they have an email, you can include the email instead. I think we're handling those on a case-by-case basis. If they have a landline, certainly include that, and include some sort of, when you're uploading your documents, just include some sort of affidavit or, document explaining what kind of contact information you have for the tenant.
And no, all good. This was another question, and I think this is kind of to the the changes of the pathways and some of the notices and things like that. Who is making the rules on like how the program is administered? I know I don't know if there's official regulations that have been set up by the city, but essentially like how can landlords get those official regulations, that way they know and understand how the program exactly works, which I know is kind of like on a rolling basis right now.
Sure. Yeah. I know that, yeah, there aren't written regulations, but I think this is all being done, I guess. DHCD oversees the program. I guess they're the ones that decide, I guess, how the program, how it operates.
Gotcha.
Before you asked another question, I saw one in here that I think might be important to answer, which was, can a property manager handle everything? And as long as the property manager has the authority to negotiate on your behalf, absolutely. So anyone who has the, whether it's a property manager, an attorney, such as someone that works in your office, if they have the authority to negotiate on your behalf and enter into an agreement, then they can handle it. They can handle everything.
And just to sort of piggyback on that, again, sort of a general situation, the property manager might have the authority, but something might come up in the mediation and the property manager might think, I really should run this by or an attorney might think, maybe I should run this by my client or the landlord. And so because that happens fairly frequently, frankly, it's a good idea to have, and in fact, I think it might even be part of the good faith definition. It's a good idea to have the landlord at least available by phone. If you're not sure whether you can agree to something, whether your client or the landlord, actual property owner, would agree to something, you can ask, could I just put this call, could I drop off the call for a minute, call and consult the landlord? But again, you'll want the landlord to know when the mediation is happening, so that they can be available in case something like that comes up. And you can just call them, consult with them, and the mediator and the other parties will wait on the line, and you can just come back and proceed with the mediation.
Gotcha. We had another one that was recently, they've been receiving emails from Diversion stating that you have reached, that you have to reach a tenant directly to mediate. What is the point of the diversion through the city of Philadelphia without a housing counselor, as landlords are filing for diversion after they've tried to mediate with the tenant and was not successful? So essentially what is the point of diversion at that point, once a landlord has proactively already tried to go through mediation, not the official side?
Yeah. You're thinking about the sort of direct negotiation pathway. Well, I mean, one of the things that we've, I think, seen, right, I represent tenants, but I'm in municipal court all the time, and one of the things I've heard from a lot of opposing counsel is that as a result of this, they're getting tenants contacting them proactively at a much higher rate than they were before. So it sort of prompts prompts the parties and connects the parties in order to try to negotiate, work something out. Know that a lot of people on the call definitely do work really hard to try to work things out with their tenant before even getting to court or before even applying with the program. But having the city prompt someone, hey, you should do something because this is serious, because if you don't, you're going to have to go to court and be evicted. I guess we do see that prompts a number of tenants to actively engage.
We hadn't, I'm sorry, I just lost one I had set up here. What is the criteria for a case being scheduled for mediation?
Yeah, I'm gonna direct you to DHCD because they're making the decisions on this, and I think that they're also, it's sort of I think there's a bunch of things that go into it, and then I think it's also sort of changing and flexible as because what they're doing is they're trying to look at how to use the program in order to maximize the number of landlords and tenants who can avoid court, and so I think that they're actively working on what's the best way to format that.
Right. We had two other ones. The first one is should we all be sending out notices to quit before sending them to the diversion process? Or I'm sorry, should we still be sending notices to quit before sending them to the diversion process?
I think there isn't a requirement, right? You can send the diversion notice and the notice to quit at the same time. Like you don't have to wait to send a notice to quit.
Got it. And sorry, I'm losing some of these here. There was one more here that I had. Can you actually, I know we talked about these different pathways, and I know the criteria is not fully laid out, but can we talk a little bit about like those different pathways and some of the standards or some of the requirements that you're looking at for pathway 1, pathway 2, and how a landlord gets notified for those different pathways?
Well, the second question's much easier, which is how they get notified, which Sue, I think maybe.
Yeah, the notification, will clearly say your whether or not a mediation has been scheduled. And if the mediation hasn't been scheduled, it'll say, here's some resources. So you'll know in the notification which pathway you've been assigned to.
Gotcha. And to kind of piggyback off of that, if you're put on the alternative pathway, how long do you have to wait to file in court? So for example, if you reach out to the tenant and don't hear back in a few days, can you at that point then file?
At least the way that we've heard that the city is interpreting the legislation is that there's still that 30-day time window that you got to wait.
Yeah. I think you may have briefly touched on this earlier, but I just wanted to make sure we answered it. Do you need a letter from the eviction diversion program approving imminent harm, or can you go straight to the eviction court with all the other required documents?
Yeah, so the program wouldn't make a determination on the imminent harm. Like the imminent harm is just a court thing. So if you're in a situation where there's imminent harm, yeah, the next step would be to just file in court, have that documentation of imminent harm, and then it'd be the judge that's making that determination.
Gotcha. And there was one more question, because I'll have to stop the questions here just to be respectful of everyone's time. But when a lease term has ended, can you talk about that process of going through the eviction diversion program when the lease term has ended, for example, for 1 year? Given that it's already a contractual obligation from kind of both parties, and how that process works once the lease ends, and then you have eviction diversion that kicks in.
Yeah, so once again, this was one of the changes that City Council made for this year, for the most recent version, because right, the version that was created back in 2020 was once again only for non-payment of rent, not for termination of term or the ending of the lease. But City Council expanded it to encompass all landlord tenant cases, with the exception right of imminent harm. So right, even though it's just the ending of the lease, also you would have to go through diversion before being able to file in court.
Right. Yeah, so the one thing I did just want to add is this program obviously has been something that City Council adopted. Just to kind of give a refresher, this program does sunset at the end of this year. There obviously, I'm sure, will be a push to do something with the program, whether it's permanency or extension, or City Council has to reassess that. So that's something that'll happen at the end of the year, and obviously we would welcome the feedback from any landlords, property managers as well. Obviously I know CLS is on the call. From the tenant side, we'll be at the table for this discussion, but that's where the program is at currently, and when it's supposed to sunset. But with that, I want to once again thank Vikram and Sue, and I was wondering, Sue, if you wouldn't mind just dropping the email address for those folks who had specific questions related to their cases, if you wouldn't mind doing that. But really appreciate everyone joining us today. I know we have a lot of challenges, we have a lot of questions, we have a lot of concerns about the program, but this is really how we want to continue to amplify those concerns and those questions in a very respectful way, and hopefully get some of these procedural issues addressed. So I'm going to keep this open for a few more minutes. That way everyone can copy the email address. And if you have any questions, from the landlord side, whether you're a PAA member or HAPCO, feel free to reach out to your representatives, as we're working closely with Sue and Vikram here. And Sue just dropped the email address. So if you have specific questions, feel free to email the folks over at Core Services with those questions. I'm going to leave it open for a few more seconds. But once again, really appreciate everyone's time today. And Sue and Vic, as always, thank you.
And thank you, Andre, and thank you everyone for being here.
Thank you.